Hello and welcome again to In Your Corner. 1-855-821-5900. Help at inyourcorner.ca is the way to reach out through email. John Scholes, Sivan, and James. We're here ready to fill your head full of knowledge. We're going to get to a success story a week that was with you, Sivan, very shortly. And we'll get to the top 5 myths about long-term disability a little later on in the show, so stick around for that. First up, James, what do you got for us, pal?
Well, one of the things we try to do with this show every week is we try to give the viewers some knowledge, and that's ammunition in the fight against your long-term disability carrier who's denying or cutting off your claim. And what can you do to put yourself in a better position? That's what we're always trying to do with our clients. So the first thing that anyone who is receiving or has been denied long-term disability can do is get a copy of the policy. That is what the entire relationship is based on. And familiarize yourself with it. Read through it. You may not understand all of it, but you're going to be a lot further ahead if you have a copy of it and you've at least given an attempt to familiarize yourself with all of the issues involved. Next thing, do what you're doing right now. Watch the show. There is a lot of information here. If you're watching the show right now, you are further ahead than many people are. If you're in the Toronto or Ottawa area, we have a radio show that's on every week. You can listen to that. And the last thing is give us a call. If there's something that doesn't make sense to you, or there's an issue you're having, or if you've been cut off or denied, call us. It's free information. There's no risk whatsoever. You give us a call, we will talk to you. If we want to go further with it, if you want to go further with it, that's fine. But if not, we're more than happy to discuss on that basis.
I think it would be a phenomenal statistic to see people who have got a disability policy and they've just tucked it away behind last year's taxes. Nobody reads it. It's brilliant advice. You got to be familiar with it, right?
Sure, absolutely, and use it actively.
Right.
So if your insurance company is asking you to do something and it's getting your spidey senses tingling, it doesn't seem to make sense to you, ask them, say, where in the policy does it say that you're allowed to do that?
Right.
If they are saying, oh no, you can't see this treatment provider, this, let's say, psychologist that you've been seeing for treatment, you have to go see this other psychologist that we're recommending to you. Well, no, show me where in the policy it says that you can choose who my treatment provider is. Show me exactly where. And if you have a copy of the policy, it makes that process a whole lot easier.
Sivan, what do you got for us? Success story? What happened this week?
Well, John, you know, this is interesting. So just on something that James said, you know, we are lawyers. People need to understand that. We are but some people don't understand that. They think that we're just here maybe from the insurance industry. No, we are lawyers. We deal with this day in and day out. And the show that we are doing here on TV and on radio is the only show of its kind in the country. There's no other show dedicated to disability rights, injury rights of people who are fighting insurance companies. So let me tell you about a call that I received this week from a gentleman, his name is Jerry, who watches this show. And it's about his wife, 48-year-old wife who's a nurse, an emergency nurse, and she's been an emergency nurse for over 15 years. She had a stroke about 6 months ago, and she applied for long-term disability. And the insurance company wrote back denying her claim for long-term disability on the basis that she's not, quote-unquote, totally disabled, something that James and I have spoken about quite a few times here. And her husband, she's in no position to contact us, so her husband contacts us and says, well, what does that mean, total disability? Does it mean she has to be in a coma? Because he says to me, her neurologist says that she can't work. She has memory lapses, memory issues. She has partial paralysis. It is insane to think that the insurance company has taken the position that she's not entitled to long-term disability because she's not totally disabled. And I want to bring this out because there is a misconception out there. Again, we've spoken about this quite a lot. That people think that total disability means that you are completely and utterly bedridden. That is not what total disability means in the context of long-term disability. It's not. And what people need to understand is that as long as they are unable to work, as long as they have doctors who say in writing that they are unable to work, they are totally disabled pursuant to whatever LTD policy they are going to apply under. And again, as James put it, look at your own long-term disability policy. You will see a definition section. You can even look what it means to be totally disabled. And it will not say that you have to be, you know, bedridden. So that's very important. And if you have questions about that, then you contact us the way that Jerry just did. And we're going to be able to help his wife. In fact, I actually don't think that we're going to have to start even a legal claim here, although in most instances we do. I think that perhaps an email from us or a letter from us from our office is going to be enough to put the insurance company in its place. And guess what? If not, We are going to take it one step further. We're going to apply tremendous pressure on the insurance company, and they are going to come to the table, and they are going to ask for a settlement, not our client.
So this applies total disability. You don't have to be swinging a hammer or roofing to be totally disabled. You can have a desk job. If you can't do your desk job, your doctor says you can't do it right now, you qualify, right?
Total disability means what it says in the policy. Forget what it sounds like.
Right.
They use those words for a reason to make you think it means something other than what it actually means.
Right.
All it means is exactly what it says in the policy. And in virtually every policy we look at, totally disabled is defined as not being able to do your occupation because of an injury or illness, or after 2 years, any occupation because of an injury or illness. But it's just related to the extent your disability prevents you from working. That is the only analysis that is necessary to determine if you are totally disabled.
And you know, John, we also talk to doctors sometimes, psychologists, psychiatrists, orthopedic surgeons, family doctors, and they are also mistaken in their view, right? I mean, when the individual comes to them and says, can you write me a letter saying I'm totally disabled? The doctors themselves are confused by that language because from their standpoint, treating people day in and day out, they understand as medical professionals what a total disability means. But it's not what the insurance company means. Right. It's not that context. And so oftentimes we find ourselves explaining or even educating these medical professionals who have the best of intentions, but may perhaps write a letter saying, no, this person is not totally disabled, where in fact they are under the policy. Again, we find ourselves in positions where in many instances we are correcting some of the messaging from the doctors, but individuals who are in a situation where they're fighting an insurance company, they don't know how to speak with their doctors about this. The doctors are confused. And again, this confusion is deliberate. Just think about that, John. If a doctor says this person is not totally disabled because the doctor doesn't understand what that means, that's something now the insurance company is going to weaponize against the disabled individual. And that's something that once we see, we can correct and boomerang that against the insurance company. Nice. And again, that's when they come to the table and we start negotiating and start resolving the case on an equitable basis.
Reach out 1-855-821-5900, help at inyourcorner.ca. You did mention, of course, James, the radio show and here in Toronto and Ottawa we host, you host, and also your pal and partner, Lior, has a radio show as well, the Employment Hour and 30 on TV. Get a ton of phone calls on the radio show, and a lot of them have to do with the crossover between disability and employment. So we cherry pick those ones, we play them back, and we comment on the ones that have to do with what you do here on this show. We'll get to our first call of the day right now.
I was cut off long-term disability because my adjuster saw photos of me on Facebook sitting and smiling at my sister's wedding 3 months ago. I'm just devastated. My psychiatrist even wrote to them and told them that I still can't work, but they won't budge, and I don't know what to do.
So this obviously brings up the issue of social media and how it's used in long-term disability claims. In this particular case, this woman's long-term disability insurer has seen a photograph of her smiling at her sister's wedding and is saying, well, that means that you're no longer depressed. And that seems to be what her issue is here, which is absurd. Anybody with any common sense is going to understand that. You don't need to be a psychiatrist to understand that someone with depression can smile, especially if they are at their sister's wedding. Mm-hmm. So from a legal standpoint, no, there would be no basis for the insurer to deny your claim just on that basis. But that doesn't mean that they won't, as they have. They do it all the time. They will use anything that they can sink their teeth into in order to cut off your claim. Any justification they can find to cut off or deny your claim, they will use. And if it is what is otherwise a pretty innocuous photo of you smiling at your sister's wedding, sure, they'll use that. I'm not the least bit shocked to hear that they've done it. We see it all the time. So this brings us to the practical part of it. What can you do? Mm-hmm. So from a practical standpoint, if this hasn't happened to you yet and you are getting long-term disability insurance or you're about to go on LTD, consider how much you want to be out there on social media. We had on a radio show not long ago an investigator who suggested that people ought to go dark. Now, that was his words. I'm not sure I really expect my clients to do that. Realistically, I know a lot of people are just too engaged in social media to go that far. But you really should consider your privacy settings, making sure that nobody that you don't know can see what's on there, and that nobody can post anything to your wall or tag you in photographs without you permitting it. Use common sense. On the other hand, if you're in a position like this lady and you have had your benefits cut off, or they're threatening to cut them off because of something you've posted on social media, you give us a call. We'll start a legal claim. If that is the basis they are using, that's all they're basing their denial on, then they're in some hot water, and we're going to be able to use that against them.
Maybe just think twice before you hit post. I mean, it'd be maybe something like you said, completely innocuous, but just, you know what, maybe I'll leave this one off.
Absolutely. You want to be careful. You want to use common sense, even if there is nothing about it that is that should be relied upon. Right. Think about it from the other perspective, and you want to make sure that they have nothing to use against you.
Gotcha.
If you're giving that to them, they're going to use it. You want to get your benefits for as long as you can.
Top 5 myths about long-term disability. That is coming up after a short break. Hang on, we'll get to that, so stick around. 1-855-821-5900 and inyourcorner.ca. In Your Corner continues right here. Stand by. You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to inyourcorner.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca. And welcome back to In Your Corner. You want to reach out anytime, get a hold of Sivan or James, no problem. 1-855-821-5900 and help at inyourcorner.ca as well. As promised, we're back for the break, guys. Top 5 myths about long-term disability. I know it took you guys a little time to whittle this down from 100, so we got it down to 5. They're all important, and I'll just start throwing them at you. Number 1, if I am denied or cut off LTD, there is nothing I can do. I am absolutely powerless.
So nothing can be further than the truth. That's what the insurance company wants you to think. And I have to tell you, John, that having worked on the insurance side and having defended insurance companies, they are more afraid of you than you are afraid of them, okay? And I'll explain that in a second. The reality is this: you are a liability to them. As soon as they cut you off or deny your claim, assuming you have a legitimate claim, you are a liability. You represent money that they have to pay out. So when I say that they're afraid of you, they're not afraid in the classic sense of fear, right? This animalistic thing that we feel sometimes. I mean that the insurance company has to answer to its shareholders. You know, they have a hierarchy there. It's a bureaucracy. It's all about money. Mm-hmm. So for them, every time they have an individual who is potentially out there and can potentially make a claim, they are hoping that person will simply walk away. They're afraid of that person making a legal claim. They would much rather that person appeal the decision, right? When they deny your claim, they send you a letter, they say, you can appeal that denial, you can appeal that cutoff. They would rather you do that because then they maintain control over the process. They're not afraid. As soon as you have us or a lawyer that deals with long-term disability, as soon as we take that extra step and get it into that legal sphere, they are now bleeding money because now they have to defend the case and they know that ultimately they're going to have to pay out the claim. Maybe not the whole claim, maybe a portion of it, but you now become a liability for them. So they're afraid of that. But most people out there, when they are denied or when they're cut off, they feel that they're powerless. It's $1 billion company. There's me, small person. I'm injured. I'm sick. I can't do anything. Wrong. If your doctors are saying that you are disabled and you were denied or cut off disability, you have a lot more power than you think. That is the myth that we have to break. As soon as people realize that, I am telling you, insurance companies just change their tune. And I'm telling you that not only as someone who represents these individuals, as someone who worked for insurance companies in the past and has been on the receiving end.
Another LTD myth. I don't need an insurance lawyer to help me with my LTD dispute. I can do it all on my own. Thank you very much.
Well, it's interesting. I'm going to pick up on something Sivan was just saying, that he used to work for insurance companies doing defense work. I don't love to admit this, but I did it too at the beginning of my career. But having done that, both Sivan and I are quite familiar with the process of defending exactly these kinds of claims. And one of the first things that you do, you assess the file, but a big part of that assessment, and I would argue maybe the most important factor in that assessment, is who is on the other side, who's representing the plaintiff. Is this someone who is experienced in disability law? Is this someone who is going to know what to do, when to do it, and very importantly, is this someone who, if they need to, is prepared to take the case to trial? Doesn't mean that they're going to do it every time, but is this somebody who, if the insurance company is not going to be reasonable, will force them to go to trial and get a decision from a judge? And if that is the case, then the assessment that that lawyer and the insurance company will have of the case at the beginning, which is critical, the assessment they have at the beginning is going to be considerably higher. They are going to set aside much more money for that claim at the very beginning if they see that there is an experienced lawyer on the other side.
So, by yourself, not even a question.
No, absolutely.
They're looking like, really? You're going to take us on?
If you are unrepresented, unless you happen to be a disability lawyer, then almost certainly the insurance company is going to devalue your claim. They are going to offer you a fraction of what they otherwise would if you were represented by an experienced disability lawyer.
Now, you want to reach out anytime, 1-855-821-5900, help@inyourcorner.ca. We're talking the top 5 myths about long-term disability. On to our third one, guys. The insurer says that I have insufficient medical support. We've heard that before for my LTD claim. So once again, I guess I'm out of luck.
So I'm going to buy that if the insurance company says that, if you've submitted a medical note on a napkin that says this person is disabled and that's it.
Have a nice day.
But if you have a letter or a report from your doctor or doctor's psychologist, whoever's treating you, that outlines the diagnosis, if there is one, the impairments, the limitations, if there's meat to the letter that explains medically why it is that you're unable to work because of your disability, your illness, your injury, whatever it is, well, then the insurance company coming back and saying there is insufficient medical documentation, on the basis of that we're denying your claim, that is bull. Okay? Now, sometimes they'll ask for clarification.
Right.
And that's okay. I have no issue with the insurance company asking for clarification. I have an issue with them having the necessary information and then simply spitting out this letter or this denial note saying it's insufficient. I don't know what that means. Again, unless you've submitted a napkin with a one-liner, they should either approve your claim or ask for clarification, and we can help in all of these circumstances. If you don't have any medical documentation supporting your disability, well, then they're also correct to say there is insufficient medical documentation. But again, many people who contact us have submitted not just one report, not just two, but volumes of documents, clinical notes and records from their doctors, from the hospitals, and yet the insurance companies come back and say insufficient medical documentation. It is baloney. We can fight it. And I'll tell you this, as soon as we start that legal claim, when we get involved and we take over, they fold like a house of cards and they start shifting to a different reason for why they denied the claim. So we are on the attack. So again, if that's why you were denied your claim, don't just take that at face value. Give us a call. It'll take us literally 2 or 3 minutes to review your documents to tell you if in fact you have a case against the insurance company.
James, that call seems necessary because at one point during this, the doctor might even say, what else do you guys want, man? I've given you everything. This is heavy detail, but they're still denying it or saying you have insufficient information.
Yeah, I mean, that's quite intentional, too. The way that they word it, the insufficient information, you know, if they were being genuine, if they were really trying to get the bottom of it, they would say, well, your doctor said this, but please ask him to explain why that means you can't return to work.
Right.
That would be a good faith effort to really understand what's happening, but you don't see that. What you see is exactly what Sivan was talking about. There's insufficient medical evidence to support it. They don't tell you why. And the reality is, in most cases, it's because there isn't a reason why. They've just decided this is one we think we can get away with denying, even though the doctor is clearly saying can't go back to work.
Top 5 myths about LTD. Number 4 is I have to try to go back to work or else the insurer's in the right and denying me or cutting me off LTD. I got to go back. I got to go back.
Well, the first thing that we should really make clear is what the decision on whether or not to return to work is about. So if you are injured or impaired, that decision, whether or not you are working, that's a medical decision.
Right.
That is a decision that you have to make with your doctor. It's not a legal decision. It's not an insurance decision. This is a medical decision, whether or not you are healthy enough to return to work. And because of that, the only criteria that you need to apply in deciding whether or not you should go back to work and when you're ready to do it is what your doctor is telling you. If your doctor is saying you are okay to go back to work, sure, then yes, you have an obligation to at least try. But if your doctor is telling you that you cannot return to work, you can't go back to work, even if your insurance company is saying you have to go back to work or we're going to cut off your benefits. Because if you do that and your doctor is saying you can't go back to work, you're jeopardizing your health.
Right.
You're going to make things worse. And don't think that your insurance company is going to be there for you to pick up the pieces if you try and go back to work and it's not successful. They're going to say you didn't try hard enough. So you're damned either way, my friend. It doesn't really matter. And if that's the case, you might as well listen to your doctor. Now, if they have cut you off because you've refused to go back to work on your doctor's advice, you give us a call. We start a legal claim. And it's as we've talked about on this show time and time again, it's a straightforward process. As long as your doctor is supporting your decision, you're going to have a strong argument.
Again, top 5 myths about long-term disability. Number 5, guys, all has to do with this. Says I can't hire an insurance lawyer to help me with my LTD because I don't have the money to pay for the lawyer.
So that's, again, very important people to understand. We understand that when people are fighting an insurance company, they're in a very difficult financial state. They have no money coming in. They have bills to pay, perhaps a mortgage, kids' activities, etc. We don't charge a dime. We charge absolutely nothing unless we're able to recover money, unless we're able to fight the insurance company, force the insurance company to pay money that they, before we got involved, said they're not paying a cent from. So you are not actually shelling anything out of pocket. You're not taking out your checkbook, a Visa card, nothing. And frankly, that actually makes us a little bit more selective as well, because obviously we need to make sure that if we're able to help you, we get paid, we're able to pay our assistants, our office. But it means that if we're telling you that you have a case, we are banking on it. We are with you in the same boat. Now, I have seen situations, and we've talked about it on this show, where there are lawyers out there. For the life of me, I don't know why they're doing this, but they will take an upfront retainer. So they'll take $2,000, $4,000, $5,000, not even to start a legal claim, but to do an appeal. That we've talked about, I don't know how many times here, is a waste of time and money. And one case comes to mind with a lady who had seen the show, contacted us, and then told us that the lawyer she chose, unfortunately, charged her $8,000 to do an appeal. And when that appeal failed, which of course it would have, then he told her, okay, now we're going to take X amount from whatever settlement we get for you down the road. I mean, that is obscene as far as I'm concerned. That lawyer is welcome to do whatever he wants, but that's obscene. It is completely inappropriate. It's not the way we operate. And we tell people, listen, if we can't get a settlement for you, if we can't get the resolution for you, if we've miscalculated for whatever reason, you are not paying us a dime. And there's no fine print here. You're just not, period.
It's an interesting thing that you raise, because I have clients time and time again, after we start the process, say, okay, James, but really, do I have a case here? And I say, well, listen, I'm not getting paid, and my firm isn't going to recover our expenses unless you do. Yeah. So the fact that we've signed the retainer agreement and that I'm going to start the claim for you means I feel pretty strongly that, yeah, you've got a claim here. Yeah. So that is the way it works. Yep. You don't pay us anything. We only get paid if we're successful.
help@inyourcorner.ca is the email address, guys. I want to get to an email as we roll on here. Rowan writes in, says, my wife stopped working 2 years ago due to anxiety and depression. We were informed that her LTD payments will end unless she goes for treatment with the psychologist the adjuster wants her to see. She's already been seeing her own psychologist. Does she have to change doctors?
So this is something that we've already talked about and addressed on this show. Absolutely not. Yep. For sure not. And as I spoke about right at the beginning of the show, ask them where in the policy it entitles them to do it. Say, show me the provision in the policy that says you get to choose who my treatment provider is and that you're allowed to force me to move from one psychologist to another. It doesn't exist. They're not entitled to do that. And if they insist on doing that and they start threatening that they're going to cut off your benefits or, in fact, do cut off your benefits because you refuse to see their chosen treatment provider, they're going to be in trouble. They're going to be exposed to punitive damages there, and they don't want any part of that. So you make sure, number one, to ask them to show you where in the policy it allows them to do it. But just as importantly, put it in writing. Make sure they are putting it in writing that they are requiring that you see this other psychologist. And if they're not prepared to put that in an email, you do it. You take notes of every conversation that you have, and you make sure you send that to the adjuster immediately after each phone call, saying, this is what you told me. You told me that I'm required to move from this treatment provider to another treatment provider that you're choosing, and if I don't, you're going to cut off my benefits. And if they have an issue with that, then they're going to take it back at that point in time, and if they don't, they're stuck with it.
Gotcha.
You know, John, my concern with these kinds of requests from insurance companies is that, you know, what's their agenda? Why are they insisting that you go to their rehab specialists, their psychologists, their doctors for treatments, not assessments?
Right.
My concern is not so much that the doctors they're choosing are bad doctors. I don't know these doctors. Some of them we do, but we don't know some of them. My concern is that there is an agenda, just like if you have a car accident and they want you to go to this specific mechanic.
Body shop,
Yeah, why is that? Yeah. And the concern that I have is that, yeah, that individual is going to be treating you, and then 3 months later, they're going to write a report that's more favorable to the insurance company. In other words, they're conflicted because they're being fed work by the insurance company, so they have an incentive to produce something that helps the insurance company. And so that's where my concern is. And I'm not saying it happens in every instance, but again, that's why I'm very suspicious of these kinds of requests. And it goes to James's point, show me where in the policy it says I have to go to someone you recommend and you choose.
Moving forward, when your LTD claim has been denied, we'll cover that after a short break right here on In Your Corner. Stick around.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to inyourcorner.ca.
You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back to In Your Corner. We'll get to a place we call mydisabilityquestions.com. You can go there anytime and ask your questions. James, I got one for you quickly here as we're just about to wrap up for the day. Mydisabilityquestions.com says, I'm on my third appeal after a year and a half of fighting the insurance company. What's your best advice on how to have my claim move forward?
My God, stop appealing.
Stop it.
Stop. If you're watching this show, you already understand that appealing is a waste of your time. All you are doing is you are giving the insurance company power for longer.
Wow.
As long as you appeal, they can make whatever decision they want. And guess what? If they're basing the decision on the information they already have, and you try and give them another note from your doctor, do you think it's going to make a difference? Nope. No. If you appeal, all you are doing is you are delaying the resolution, and you only have 2 years from the date they denied you. If you appeal, the clock does not reset.
That's scary.
Stop appealing, give us a call, start a legal claim, get a resolution.
How many times can they do it?
They can do it as many times as you'll allow them to.
Wow.
If you want to do it 4 or 5 times, I would almost guarantee that every insurance company out there will allow you to do it.
Great advice to wrap up for the day. It was a quick one, but we got more coming up in the coming weeks. You want to reach out, it's 1-855-821-5900. You got help at inyourcorner.ca. And for more details on the show anytime and find old shows, inyourcorner.ca as well. We'll see you next time on In Your Corner.